All right, everybody, welcome back. I'm glad everybody was able to get your lunches. Our seventh speaker of the day is our very own Professor Gerry Beyer. He joined the faculty of the Texas Tech University School of Law in June 2005 as the first holder of the Governor Preston E. Smith Regents Professorship. He's the recipient of dozens of outstanding and distinguished faculty awards, including the Chancellor's Distinguished Teaching Award, the most prestigious university-wide teaching award at Texas Tech. In 2015, Professor Beyer was awarded the Accredited Estate Planner Distinguished Designation at the National Association of Estate Planners and Counsels annual conference, where he was inducted into the Estate Planning Hall of Fame. Professor Beyer's Wills, Trusts, and Estates Prof blog is the number one ranked estate planning blog in the U.S. and has been for 5 straight years. And in 2015, his blog was also inducted into the ABA Blog 100 Hall of Fame. He has authored and co-authored numerous books and articles focusing on various aspects of estate planning and has won awards from the ABA's Probate and Property magazine for his writing 3 times. He's one of the most downloaded law authors on the Social Science Research Network. Professor Beyer is the editor-in-chief of the Reptile Law Reporter, the official publication of the Reptile section of the State Bar of Texas. He's an academic fellow of the American College of Trust and Estate Counsel and a member of the ALI. Professor Beyer serves as a mentor to many students, including myself, in various law school organizations, as well as participating regularly in pro bono activities. Last and most importantly, he is the advisor for the Estate Planning and Community Law Property Law Journal, without him, none of this could be possible. Today, Professor Beyer will be giving us a case law update. Please join me in welcoming Professor Gerry Beyer.
All right, good afternoon, everybody. Thank you, Ashley, for that overly kind introduction. I also thought this, what she said earlier, she said, we're going to have a working lunch. No, I'm working, you having lunch. Doesn't just quite seem fair. All right, well, while you're getting your lunch and everything, I thought we would look at a few other recent estate planning developments that aren't really related to case law, simply because it would be good for you to have this general knowledge about other estate planning developments when you deal with your clients. The first one we're going to talk about is what's called the Urban Death Project. And what the Urban Death Project is advocating. What they're saying is that a better way to dispose of human bodies is to compost them, okay? Because it's more environmentally friendly. So what you do is you take your loved one's body to this company. They will compost it. Then, about 4 months later, you come back, you get the compost that has accumulated, and then you put it in your gardens. And then you grow stuff with your family's remains, and it costs only $2,500 per body. Now, what do you think about that? Good idea? Or just a tad too close to Soylent Green for your preference? It's people. All right, next. You are aware, I'm sure, of the growing number of states, in fact, California just did it, enacted statutes authorizing physician-assisted suicide. Now, the typical method that you use is you take drugs and then you die. Well, that's too much like, capital punishment in the states that have it, where they give people drugs and they die. So there are some that are saying that assisted suicide by drugs is not a very, very dignified death. So this gentleman, he has designed a roller coaster, and it is 160 stories tall, and it holds 24 people at a time, and it just drops them for 1,600 feet till they reach terminal velocity that enters 7 more big loops to make sure that hardy riders do not survive. And death would be caused by the extreme G-forces of this. I'm serious, I don't make any of this up. All I know is that all my life I have disliked roller coasters. And now I know why. They're just too low to kill you. That's all. Now, the next recent development is from a company called Blockchain Apparatus. And what they're doing is they're developing computer software code to substitute for human executors and administrators, so that when you name an executor or administrator in your will, instead you simply name this software product. And then upon death, it will connect with the internet and handle everything that's necessary to probate your will. What do you think of that? Or is that just like, first step towards Skynet? Dave, can't do that. All right. And the last recent development, some people are kind of afraid, that when the Grim Reaper comes and you die, you're not going to have many friends or family coming to your funeral for whatever reason. So that has happened in other countries. And many other countries have developed a technique to encourage greater attendance at people's funerals. And the way they do this is they hire exotic dancers to perform at the funeral service. And they say that attracts more mourners, which makes the deceased person look more important. Now, of course, as you saw earlier, we have a new form for the appointment of an agent to control disposition of remains. So if that's something your client would like, you have a document where you could actually provide for it. All right, so that's just to tell you a few of the things that your clients are going to be hearing about estate planning developments, because they certainly aren't going to know about the recent cases that we're going to look at, and that's what we're going to turn our attention to now. We're going to examine recent Texas judicial opinions from 5 main areas: intestacy, wills, estate administration, trusts, and other estate planning areas. Now, this past year has been a little different. We've had fewer appellate court cases in our area than in almost any year that I can remember. But on the other hand, we've had not 1, not 2, but 3 estate planning related cases decided by the Texas Supreme Court. So we'll be sure to spend a little extra time talking about these 3 cases. And of course, as we discuss each case, I would like you to pay attention to the lesson, the moral that you get out of the case, so that you can use what has happened in the past to do a better job planning and administering your client's estates, trusts, and non-probate assets. So we'll start now first with cases dealing with intestacy. And as you know, the vast majority of Texans die intestate, but there's something peculiar about them. They don't really engender much appellate litigation. And in the past year, we don't have any. So we can go straight to cases dealing with wills. And the first case dealing with wills is the in re estate of Helmsley case out of El Paso. Now, that last name, Helmsley, might ring a bell to some of you because it was the actor's estate who portrayed the character of George Jefferson on several television programs. And what happened in that case is that the probate court determined that, yes, indeed, he had full capacity when he wrote his will. But there were people contesting the will. They contested. And what the appellate court did is look at the evidence of capacity. Here's the type of things they looked at. Well, they looked at the evidence of the attorney who had drafted his power of attorney. And he said there was no doubt that capacity existed. When asked why he didn't do the will, he said, I was afraid there'd be litigation, and I didn't want to get involved in any litigation because he was a famous guy. And so he went to a different lawyer. And then they got that lawyer to come testify. And that lawyer said, man, I have absolutely no doubt that he had capacity. The 2 witnesses that were there, the notary, a registered nurse that was caring for him, all of them testified that they had no doubt that there was capacity. But of course, that didn't stop the contestant from trying to contest the will. And the appellate court, of course, rejected the contest and said that there was more than enough to support the finding of capacity. But what it does show us is that regardless of how competent a person is at time of will execution, family members who are dissatisfied with the terms of that will may still contest anyway. And that is an argument why I think that Texas should adopt an ante-mortem probate procedure so that a will could be probated while the testator is still alive, as other states such as Ohio, North Dakota, Arkansas, Alaska, recently somewhere up northeast did it. New Hampshire, Vermont, somewhere over there. Anyways, so we could solve this problem, but I don't think Rectal has any great interest in doing that. All right, the next case will become our first Texas Supreme Court opinion to discuss, which was decided just earlier this year. So this case is probably only about 4 weeks old. It's the Hyson versus Dawkins case. Now, this case all starts off with a testatrix who devised surface rights to tracts of land of different acreage to each of her 3 children. And the children also received mineral rights to those properties, but they were subjected to various royalty interests. No problem existed while the children were alive, but what happened is that after all the children died, the grandchildren were fighting over the share of their respective parents. One group of descendants said the will only granted a fractional royalty to each child, which would give certain children only a 1/24th interest, whereas another group argued that the children were intended to share all royalties equally, which would have given 1/3 down each family line. Well, we first had the trial court look at it. The trial court examined the will, they examined everything and said, it may have been inartfully drafted, but it is clear that she wanted each child to have an absolute equal share. Well, it got appealed. What did the appellate court do? The appellate court looked at it and said, you're wrong. There is no ambiguity at all in that will. It was clear that the children were receiving different types of interests, and they rejected the argument that they were supposed to be equal. And the court even said, it may very well be the case that she wanted the children to all be equal, but that's not what she said, and it was unambiguous, and therefore we can't fix it. By the way, some of you are thinking, well, Craig just told us all about now that we can reform a will for scrivener error, but that statute did not yet exist. Nonetheless, that's basically what the Supreme Court of Texas did. They said, look, we are not going to do this by, quote, an application of mechanical rules of construction that offers certainty at the expense of effectuating intent. So they adopted a holistic approach, and they looked at the entire will, and they said, look, it is clear that the intent reflected by the document was to give the children equal interests, and therefore reinstated the trial court's judgment. Of course, what you learn from that case is that you need to draft things very carefully, especially if you're in an area of law where it's very complex. Royalty interests and how they're divided can be a very complex area of the law that many estate planners may not be familiar with. And therefore, it may be wise to consult with an oil and gas expert to be sure that you phrase the interests that you are granting in the way that accurately reflects your client's intent. Now, the next case we're going to look at, we actually will look at it for 2 purposes. This is the Estate of Cole case decided out of Fort Worth last year. Now, the first issue we're going to look at this case for is regarding election wills. And what happened in this case, as a dispute arose as to whether husband's will put the wife to an election to either, 1, just assert her rights to her half of the community, or to give up her rights to her half in the community in exchange for all the different gifts given to her under the will. Now, the trial court looked at that, and then, without hearing any evidence, just decided as a matter of law that the will put the wife to an election. And of course, the wife was very upset about this, and so she appealed. And the appellate court looked at this and says, trial court, you got this all wrong. There was no election provided here at all. Because they looked at Texas law. And Texas law says that an election will arises only if the will is clear and unequivocal about triggering an election. And the court said that merely because he indicated in the will that a certain account was his separate property did not mitigate against other language in the will where he clearly stated, I am only trying to dispose of my separate property and my one half of the community. I am not trying to interfere with my surviving spouse's community interest. And the court said, that clearly doesn't rise to an election. And then they said, even if you think some of the different facts in this case might make it a little ambiguous, that doesn't matter, because if it's ambiguous, there's no election. It has to be clear and unequivocal to trigger an election. So what do we learn from this case? We learn that perhaps it would be a wise practice when you draft a will for a spouse to simply put in the will, I intend this will not to create an election, just to make it crystal clear. Just like I would say, if you were attempting to create an election by the will, you should expressly state, I am intending to put my spouse to an election. So just clearly state what you want to avoid this problem. But in this case, it was quite clear that no election should have been there. It was just an attempt to keep more property away from the spouse by the kiddies. Now, this case also had another issue in it, and that was a no contest or in terrorem provision. And we actually now are going to look at two cases dealing with no contest clauses, but this is the same case as the election issue we just covered, the estate of Cole case. And the husband's will had a no contest clause, which among other things said that if the wife contested the characterization of my property as my separate property, then she would forfeit all her gifts under the will. And all the wife did was make a claim for her own community property share. And the trial court, determined that the claim did not trigger the in terrorem clause. That makes sense. But then they did something weird. They submitted it to the jury to see if her violation of the in terrorem clause was in good faith and with just cause. Now, why would you ever ask that when you've already determined that there was no violation of the in terrorem clause? I have no idea, but the wife wasn't happy with the finding that she was in bad faith and didn't have just cause, and so she appealed. And the appellate court came up and said, look, there was no doubt this is not the type of conduct that would trigger the no contest clause. All she was doing was asserting the rights to her own property, which the will did not prevent her from doing, because the will clearly said that he was only trying to dispose of his half of community and his separate. He was not trying to dispose of her half of the community. And the appellate court was really puzzled about why the trial judge submitted an issue about good faith and just cause to the jury, but said, who cares? They basically said it was a harmless error. It did not hurt her at all, and just let it go. Now, the second case dealing with the no contest clause is the Ard versus Hudson case out of Fort Worth. And at the moment, petition is pending. They've applied for a petition to the Texas Supreme Court, still pending at the moment. Now, in this case, we had a very lengthy and relatively standard in terrorem provision, and one of the beneficiaries said, the executor and trustees, they are breaching their fiduciary duties, and I'm going to sue. And so she sued. Well, the fiduciaries claimed, well, guess what? By suing us for breach of our fiduciary duties, you have triggered the in terrorem clause, and you are going to forfeit your gift. And the trial judge said, you betcha. That's right. You're going to lose your gift for, trying to dispute any conduct that the executor or trustees have done. Well, that went up to the appellate court, and the appellate court very promptly reversed that case. And they said, look, a beneficiary always has an inherent right to challenge the actions of a fiduciary for breach, and that challenging the fiduciary's action for breach will not trigger an in terrorem clause. Then there was another provision. There was a condition precedent on all of the gifts that said for the beneficiaries to receive the gift, they must, quote, accept and agree to the will provisions. And the court said, She didn't violate that. She's very happy to accept and agree to all of the provisions. That her challenges were merely to the conduct of the executors and trustees, not to any terms of the will. So the result in this case would be pretty standard under Texas law, and in fact, some of this was even codified in some of the new legislation that Craig talked to us about, that inter arum clauses are designed to be effective when a beneficiary attempts to alter the dispositive scheme under the will, not when they are trying to contest breach of fiduciary actions by executors or, if it's in a trust, trustees. Now, our next case is the Stern versus Marshall case. And maybe those names sound a little familiar. It's a Houston case out of 2015, because this is another one of the cases in the very long series of judicial opinions dealing with Anna Nicole Smith. And if any of you are interested in reading about what all happened in that whole line of cases, and don't want to read the whole line of cases, this case provides just a fantastic, short, and understandable summary of what went on. Well, the key holding in this case was this. The key holding is that a claim for tortious interference with inheritance rights is deemed to not be a compulsory counterclaim to a petition for the probate of the will. Because they said a tortious interference claim is not a claim against the estate of the deceased person. It is a claim against somebody else, the person who torted upon the decedent. And if the tortious interference with inheritance rights is successful, the money doesn't come out of the estate, the money comes out of the tortfeasor's pocket. And therefore, it could not be a compulsory counterclaim to the will that they are alleging was tortiously interfered with. Now, our last wills case brings a connection between another area of the law that we don't think of as estate planners very much. Criminal law. So this is a criminal law case, McKay versus State, a Dallas case from last year, and there is also a petition filed on this case. And what happened is that we had a person, and I'm not quite sure if I remember whether it was through undue influence or duress or fraud, but using one of them evil techniques, this person got somebody else to write a will leaving something to themselves, to the alleged undue influencer, person committing the fraud, etc. And now they were charged with the criminal offense of theft, that by exerting the undue influence or fraud or duress, they in effect stole the decedent's property. And that's what the lower court held. The lower court held that conduct would be the criminal offense of theft. So if you have a will contest based on undue influence, fraud, etc., a letter to your friendly DA may be in order to alert them to the facts, because it could be actually now a criminal offense as well. All right, so that wraps up our cases dealing with wills, brings us now to estate administration cases, and we'll start with our second of three Texas Supreme Court opinions. This is the Valdez versus Hollenbeck case decided last year. What happened in this case, as the heirs sought to reopen an estate using a bill of review 10 years after the estate had been closed, and 3 years after learning that a probate court clerk in San Antonio had stolen $1.5 million from the estate. Now, the probate court denied the bill of review and said, look, can't you read the estates code? It says a bill of review has to be done within 2 years of the decision. You're bringing your bill of review 3 years even after you discovered the problem, and 10 years after the decision. So who cares whether we adopt a discovery rule or not? You are still outside of the time period. Well, the heirs, of course, were very upset about that. And they went to the appellate court, and they then, the trial court then said, however, you can do this as an equitable bill of review. And an equitable bill of review, it's It's not in the estates code anywhere. It's equitable. You get 4 years. And therefore, and it will be from discovery. 4 years from discovery. And therefore, you are within the time period. That's what the trial judge said. The appellate court said, yeah, that sounds good to us. And they affirmed. Well, the Supreme Court looked at that and they said, come on, give us a break. When the estates code or probate code from which it came from was enacted, that was to provide a statutory bill of review which supplanted the equitable bill of review concept. In other words, you don't have that equitable bill of review in an estate code context anymore. The statute says a bill of review must be done within 2 years. And you waited 3 years from discovery, 10 years from the event, and therefore no bill of review. So the Texas Supreme Court was clear on that. However, they did leave open an interesting question. They left open the discovery rule question. They did not discuss whether the 2 years would run from the actual date of the decision or from 2 years from the discovery of a reason to bring the bill of review, because in this case, it had been 3 years from discovery. So they didn't have to address that question. And so that is an open issue to see whether or not a statutory bill of review is going to have or not have a discovery rule engrafted onto it. The next case is in the matter of estate of Romo out of El Paso. Now, it's the sequence of events here that gets somewhat confusing. There was an application to probate a 2001 will. Then after that, there was an application to probate a 2006 will. The 2006 will was admitted to probate. The proponent of the 2001 will then contested the 2006 will. The court concluded that the 2006 will was invalid because it didn't even meet the statutory requirements of a valid will. It didn't even have the correct formalities, and it was no good. And the court didn't say a thing about the 2001 will. Well, the proponent of the 2006 will now appealed, claiming that the will did indeed satisfy the formalities of a valid Texas will, and appealed. And the appellate court said, sorry, we have no jurisdiction over this case yet, because they looked at the estates code. If you want to know, it's 256.101. And the section says that if there are multiple applications for wills simultaneously pending, the court has to make a decision on the validity of each will. Then you'd have a final judgment that you could appeal. But in this case, the court only had rejected one will. First they approved it, then they rejected it, but they never decided on the 2001 will. And they said, you got to wait till there's a decision on all the wills made, then you could appeal. Our next case is the In re Estate of Montemayor case out of San Antonio last year. And the trial court, after listening to the evidence, said that the independent executor was evil and removed the independent executor from office. Here are some of the reasons. He lived in the house that was the estate's main asset. He wasn't making any effort to sell the house. He was not repairing it. And he prevented other beneficiaries from accessing the house. And he made statements such as, I don't care what you do, I will, quote, live in the house until the day I die. And so after doing all that, the court said, yeah, that's kind of like gross mismanagement, and he's not performing his fiduciary duties, and got rid of him. Nonetheless, the independent executor appealed and said, I'm just doing everything just fine. That is all okay. And of course, as you would expect, the appellate court affirmed the removal, saying that the only way you can overturn a trial court's removal is to show that there was an abuse of discretion. And in this case, there obviously was no abuse of discretion. And so we learn from that if you do have a trial court order removing an executor from office, it will be difficult to get that overturned on appeal. Now, our last estate administration case deals with lost wills. It's the matter of the estate of Standifer out of Eastland in 2015. Now, what happened here is the trial court admitted the testator's will to probate, even though the proponent could not come up with an original. No original will, only a photocopy. And nonetheless, the appellate court said that was fine. See, the alleged will, the photocopy one, left everything to two children. But there was a third child. And the third child said, oh, you can't probate that copy of a will. That's no good. Because, of course, the third child wanted to get 1/3 by intestacy. 1/3 by intestacy is way better than 0 under the will. And the proponent said, look, here's what happened. We have evidence of people who saw the will wrapped up in the testator's lockbox at his house in an envelope that said, last will and testament. And then after the daughter, the one child who was disinherited, was in the house, it wasn't there anymore. And that therefore, the court said, there is a presumption that if you cannot find the original will, that it was oak. But in this case, there was plenty of evidence to show that there was perhaps some evil destruction, and the court said that the will was okay. Oh, but she wasn't done yet. Listen to the next argument she made. She said, now look, the typed name on the signature line was first name, middle name, and last name of the testator. And you know how he signed it? He just signed it with his middle and last name. He did not also sign it with his first name, and therefore the will is invalid. And the court said, where do you get that from? That's a bunch of nonsense, and they rejected that one. But she wasn't done. Oh, no. The next thing she said, an attorney didn't write this will. That this will was written by I think it was a CPA or something in the case. No, bookkeeper. I don't know if she was a CPA or not, but it was written by a bookkeeper. And that since by helping him with the will, she was practicing law without a license, that means the will's no good. And the court said, you got any authority for that? And they said, no, but it sounds good. And the court therefore rejected that argument too, stating there was no authority for rejecting a will merely because someone who helped prepare it was not a licensed lawyer. So as I said, that's the end of our state administration cases. Now we'll move on to trust cases. Our first is the In Re XTO Energy case out of Dallas. And what happened here is that there was some big cause of action, potentially, that the trustee could have pursued on behalf of the trust. But the trustee, using the trustee's discretion, said, no, we're not going to pursue this litigation. Well, the beneficiaries were unhappy about that, and then they attempted to sue the alleged defendant on behalf of the trust. And the appellate court said, there are circumstances where if you have a trustee who is breaching fiduciary duties, that you may be able to see through the trust and bring the action yourself. But to do that, you have to show that the trustee's actions constituted fraud, misconduct, or a clear abuse of discretion. And you don't have any evidence of that. All the trustee did was make a reasoned decision that it would be better not to pursue the litigation. And so the court said there was no facts to do this. However, the court said, if you want to sue for breach of fiduciary duty, you can still do that. We're not telling you can't sue for breach of fiduciary duty. We're just saying that at this point, you cannot sue the alleged defendant because you have no evidence that there was a breach yet. The last trust case, as you can see, only 2 of them of importance, is a jurisdictional question as to whether a statutory county court at law has jurisdiction to hear survival and wrongful death claims. And the court said no, and I think that's right. That's very consistent with our current provisions in the Estates Code. As we now start to, how much time I got left? What am I doing? That's okay. Oh, I don't have 25 minutes left? I couldn't. That's more like it. Yeah, I thought I only had that much left. All right. Anyways, so what we're going to do is we're going to look now at some other areas of estate planning where the Texas courts have rendered opinions, starting with the third of our Texas Supreme Court opinions, multiple party accounts. It's the Bank of America versus Eisenhower case decided last year. Now, I want you to listen to what happened. It's a very interesting set of facts. Husband and wife opened a joint account with rights of survivorship, naming 2 pay-on-death beneficiaries who we will call Beneficiary 1 and Beneficiary 2. Husband died. Beneficiary 1 went to the bank and said, hey, they're dead. Give us the money. And the bank didn't realize, hey, only one is dead. The pay on death beneficiaries have to wait till they're both dead to get the money. And so the bank issued a check, half the beneficiary 1, who's the evil one, and the other half the beneficiary 2. Well, beneficiary 2 right away, being the honest person he or she was, said, this is wrong. Immediately took that check, opened a new bank account in the name of the surviving wife, and said, this is pay on death to me. So all he did is try to undo what was done. Beneficiary 1 took the money and ran, didn't do anything else. Well, after wife died, beneficiary 2, the good one, became the wife's executor and sued the bank for the money it improperly distributed to beneficiary 1. And the jury said, the bank failed to comply with the deposit agreement, but that doesn't cause the estate any damage. It's a non-probate asset. It is not something the estate would have standing to pursue. That's what the jury said. Well, the judge said, I don't like that. We're going to grant a judgment notwithstanding the verdict. And we're going to let the estate recover that money. And the appellate court said, yeah, that sounds right. And when the Texas Supreme Court got it, they said, oh, come on now. We don't even need none of them oral argument stuff. They said, we don't need any arguments. We don't need to do anything. This is so clear that they dispensed with oral arguments and reversed. Can you imagine how that makes those appellate judges feel? That there's not even a claim to go to oral arguments, that what they did was so bad that you got all these judges, liberals, conservatives, and everything. They all say, yeah, that's wrong. You know you're wrong then. And the court simply said what the jury had said. Look, it is very true that this was an improper thing the bank did, but there is no damage. The account was a non-probate asset. None of that property would have been in the estate if the account had remained open. Now, the next thing we're going to look at is indicative of many of the things that other speakers have mentioned. And that is, the biggest area of appellate litigation has been on alleged abuses of financial powers of attorney. There were 3 appellate cases in the past year. The first one, the Dawson case out of Texarkana, dealt with standing. The decedent named his son as a party to a joint account with rights of survivorship. Then later, the decedent named the son as his agent under a durable power of attorney. Then, 2 days before the decedent died, not a stepchild, but an ex-stepchild, a former stepchild, showed up and assisted the decedent in opening a pay-on-death account, which named the former stepkids as the pay-on-death beneficiaries. And the money came from this joint account. Well, immediately, the son used his authority under the power of attorney, closed that account, and put it back the way it was supposed to be in. Well, after the decedent died, those stepkids sued and said what the son did was deprive them of an estate in anticipation, that they were hoping to get the money under the pay-on-death account that they had probably unduly influenced the decedent to enter into. And everybody said that was nonsense. The trial court, the appellate court, what they said was that the duties the son owed were to the decedent. It's the decedent or the decedent's estate that could bring an action for breach of fiduciary duty. It is not some third-party person who was hoping to be a beneficiary that they lacked standing. Now, the next case deals with the duties of an agent. The Jordan case out of Tyler. Agent was accused of breach of fiduciary duty by putting money into accounts, naming herself as the pay-on-death beneficiary. And the jury said that's wrong, awarded the heirs damages. And again, we have a court who said, no, that's just fine, and awarded a judgment notwithstanding the verdict. And the agent said, the reason it was okay for me to do this is that I was just a scrivener, using I was only following orders excuse, that the decedent actually told me to do this. However, the appellate court said that's nonsense, reinstated the jury's verdict, and says there was absolutely no evidence to prove that these transactions were fair to the principal or that the agent had informed the principal about what the agent was going to do. However, the case does raise an interesting potential problem in that the court said that the agent owed fiduciary duties at all times, even when not acting as an agent. Because what the agent was saying, when I opened this account, I was not using my authority as an agent under a power of attorney. I was acting just as a scrivener, helping him out. And the court said you can't separate like that, which might cause us problems in cases where we make a power of attorney immediately effective to give the agent authority, but we don't even give the agent the power to do anything yet. It just stands there so we don't have to go through the hassle of having the principal declared incompetent before the agent can act. So that case might cause us a little worry in another set of facts, which were very different, of course, than the ones here. The last power of attorney case is a breach of duty case, the Miller case out of Fort Worth. In this case, the agent transferred the principal's property to himself using the durable power of attorney, and the trial court said you can't do that, and ordered it conveyed back. And here was the problem: the trial court order said that the conveyance back had to be free of all encumbrances on the property. Well, on appeal, the appellate court said that went too far. It only should be free of all encumbrances that were put on the property after it was transferred to the agent, not the fact that maybe it had a big old mortgage from the past. That would then unjustly enrich the principal and the principal's estate. Well, as we come to the conclusion of our discussion of recent cases, we come to our last case, starting sort of like we did at the beginning with the disposition of the body. And this is another issue in the George Jefferson case in Re Estate of Helmsley out of El Paso. Now, we have a case here where the decedent did not complete our disposition of remains document. So there's no document. Two people are fighting over how George should be taken care of. We have half-brother versus friend. Now, in Texas, we have a clear statute that would give the priority to the brother. Friends aren't on the list anywhere, but the half-brother is. But the trial court said, no. They followed the friend's instructions because they figured the half-brother didn't have a good relationship with the decedent and all of that. So they did the ethical, moral type thing and went with the request of the half-brother. And of course, went with the request of friend, and half-brother appealed. And the court said, it's too late because he's already been buried. And so your appeal, even though you may have been right, it was a moot point, and that therefore the court did not render any type of decision. So I guess what we learned from that case is that you should have a document specifying how you'd like your remains disposed of, so there won't be any litigation about it. Well, as I said, that then wraps up my discussion of recent developments. I hope that you now see what our courts have been doing, and most importantly, I hope that you can use the knowledge from our discussion and your materials to do a better job planning for your clients, handling their estates, trusts, and non-probate assets to reduce the likelihood of litigation, or if litigation does occur because there's no way to prevent it totally, at least it won't succeed. That's it. Thank you. A second. Just expand. Get rid of that box on the right. Just close that. The one on the right.
Thinking.
Get over there.
I'm over here. It's the circle.
It's incredible how slow this is.
Okay, well, while this is warming up, thank you so much, Professor Beyer, for your always riveting case law update. Our eighth speaker of the day, actually, is Keven Stratton. Keven was born and raised in Orem, Utah. He's a graduate of Brigham Young University, where he majored in public relations and international development. Keven is currently a second-year JD student who's also earning his master's in personal financial planning here at Texas Tech. Keven is a staff editor on the EPJ. co-founder of the Personal Financial Planning Legal Society. He's a member of Phi Delta Phi International Honor Society and a member of the Dean Student Ambassador Corps. Keven will be presenting his article featured in Volume 8, Book 2 of the EPJ titled Making Millennial Money Matter, Benefit Corporations and Their Role in Estate Planning for Social Entrepreneurs. Everyone, please join me in welcoming Keven Stratton to the stage.
Still no? Oh, there we go. All right. I tell you, it's a difficult act to follow Professor Beyer, but I'll give it my best. So today I'm going to be talking about benefit corporations. They're a new entity that has come out. To begin with, though, I wanted to address why a benefit corporation might be something that would be applicable. So to do that, I want to introduce you, for those of you who have not met him, to Blake Mycoskie. Blake is an entrepreneur. He'd started 5 businesses before his most successful one. And when he grew up in Arlington, Texas, and he wanted to really make a difference in the world, and he found that business was one way that he could do that. And so he founded a little company called Tom's Shoes. You might be familiar with it. Their tagline is "Buying a pair gives a pair," probably because ugly shoes for a beautiful purpose was not exactly what they were looking for. Anyway, what they do is they go and for every pair of shoes that someone buys, they give a pair of shoes to someone in the developing country, and he went into business really to fulfill and to seek out this mission. So for him, making a profit was good and important, but he really wanted to go out of his way and make sure that he could find something that could benefit society. And Blake really isn't alone. A recent study by Deloitte, they every year put out a study on millennials. And in this last year, they asked millennials kind of their opinions about business and its role in society. And tellingly, 75% of millennials said that businesses are not doing enough to benefit society. When they were asked to kind of rank why business, what is the purpose of business, their top 3 reasons for that they gave for the businesses existing is first, job creation, benefit generation, and then also improving society. So millennials, maybe not that surprisingly, we're a little bit odd and we're different. And so this is kind of a field that is important to pay attention to. These types of people that seek their kind of a mission along with their business purpose are called social entrepreneurs. And they seek kind of this triple bottom line. They call it sometimes the 3 Ps: people, planet, and profit. And sometimes they look at it in that order. It's people first, planet, or that mission, and then the profit motive comes. So the question is, what do we do when it comes to estate planning for these social entrepreneurs? Traditional corporate jurisprudence really doesn't give much of wiggle room for directors or fiduciaries to consider the mission when it comes time to sell. And obviously, at death, that is the ultimate sale. And for a lot of these business owners, we're talking about the largest asset within their estate. So without something to help them, they really what is required of those that are administering the estate is that they have to give to the highest bidder. Otherwise, there is going to be there's a cause of action for the beneficiaries. So, and this is from the Supreme Court of Delaware recently said that concern for non-stockholder interests in a sale-type context is entirely inappropriate. So really, again, this isn't, unless there is something that allows an entrepreneur to kind of protect that mission, it doesn't have any place. So states across the nation, starting in 2010 with Maryland, have enacted statutes allowing for what are called benefit corporations. The states in red are those that have enacted it. The ones that are in white that you can't quite see are those that have not enacted it. And then there are 5 right now that are currently considering legislation for benefit corporations. You'll notice that Texas is not really considering this legislation or anything similar. So there are kind of 3 ways that a benefit corporation can protect the mission of an entrepreneur in the estate planning process. First of all, and this isn't one of the 3, but first of all, a benefit corporation, just so that we're all on the same page, is a for-profit entity. It's not a nonprofit, but it's a for-profit entity that is specifically incorporated to also fulfill some kind of environmental or social purpose. So within the incorporating documents, those purposes need to be specified. Then with that, directors are held, there's director scrutiny in compliance with that, benefit reporting, and then enforcement mechanisms that allow for this. I'm going to talk about each of these individually. First, director scrutiny. Directors are required to balance that profit motive with the social or environmental mission anytime that they're making a decision. So they are held to that standard. To that end, they held that duty is to shareholders. So within these statutes among the states, a director is not necessarily held to or a beneficiary of the benefit outside of the shareholder class. It doesn't have a cause of action against them. So if somebody's out there saying, well, you're not really doing your job exactly right, it's not that anybody can bring a cause of action, but the shareholders can. I'll talk a little bit more about that in just a minute. Additionally, every year or every other year, depending on the state, benefit corporations are required to give a benefit reporting. So they need to show what they have done to fulfill their mission. So it's not just some kind of feel good, everybody's happy, yeah, we're saving the world. These need to be measurable. These need to be measurable goals and goals that they're actively pursuing that they can then report to the shareholders on an annual or biannual basis. And finally, if the directors kind of stray from that mission, one of the shareholders, anyone who holds at least 2% or more of outstanding shares, can bring a benefit enforcement proceeding, which would require them to return back to that mission and make sure that they aren't straying too far. So now the estate planning, the estate planning implications of that. As we look at it, with these kind of closely held organizations, you're going to have 2 instances mostly that they would come up. One would be in a forced sale where there isn't really much of a succession plan. It was kind of a solo entrepreneur that incorporated on his own or her own. In a case where you have more than one partner perhaps or more than one shareholder, where you would institute a buy-sell agreement. For the forced sale kind of approach, what an estate planner can do is within the estate planning documents instruct a personal representative or trustee, as however the case may be, to find the best steward of the business's mission and not necessarily sell to the highest bidder. And because of the legal protections in place, this allows for that kind of language to be enforceable. Another alternative would be for the entrepreneur to place 2% of all authorized shares within a trust, at least those that they hold, so that they can then instruct the trustee to continue that mission and bring that benefit benefit proceeding after they pass on, should that arise if they stray too far from the mission. So by and large, this is kind of it's a new animal. There isn't much case law as of yet. The oldest state to have statutes has really only had it on the books for 5.5 years. So it'll be interesting to see how these continue to move forward. But benefit corporations truly do offer value for a social entrepreneur or anyone who is as concerned about their business mission as they are about the profit generation. Well, thank you for your time.